In this video, we're going to be talking about the case of Ivey and Genting Casinos, a case concerning what the appropriate standard of dishonesty is. In this case, Ivey is an American professional poker player, and he won a couple of games at a casino using a technique called edge sorting. The prize money that he had won that day was approximately $7 million. The casino refused, however, to pay out the money that he had won, as they believed that the edge sorting technique that he had used amounted to cheating. Ivey then sued the casino to get his prize money. His argument was that he was not dishonest by using what he thought was a legitimate technique. And since dishonesty is a necessary mens rea element to cheating, he wasn't liable under the gambling legislation, and therefore he was entitled to the prize money. The casino's argument, however, was that dishonesty is not a necessary element to the offense of cheating, making cheating a much more easier offense to prove. But even if it was an element to cheating, Ivey had been dishonest. So what constitutes dishonesty? At the time, the prevailing test for dishonesty was that laid out by the Court of Appeal in the case of Crown against Ghosh. There, the court laid out a two-pronged test. Firstly, a jury must decide whether, according to the ordinary standards of reasonable and honest people, what the defendant has done was indeed dishonest. If it was not dishonest by those standards, then that's the end of the matter and the prosecution fails. If, however, the jury decides that the defendant's actions were, according to those standards, dishonest, then the next question they must ask is whether the defendant herself realized that what she was doing was by those standards dishonest. In other words, this was a subjective test. Now, leading up to the Ivey case, the Ghosh test has been subject to much criticism. In particular, it gave rise to what was known as the Robin Hood defense. So as we all know, Robin Hood stole from the poor and gave to the rich. Would Robin Hood's actions constitute theft? Well, under the Ghosh test, so long as Robin Hood honestly believed that according to the standards of ordinary people, what he was doing was honest, then he would not be found guilty. Let's go back to the case of Ivey. Lord Hughes gave the only speech. His lordship held that dishonesty is not an element to the cheating offense under gambling law. In other words, they had found for the casino. However, even if dishonesty was an element to cheating, Ivey had been dishonest. And this was not in reference to the old Ghosh test. Instead, the Supreme Court replaced the Ghosh test with a new one. However, it ought to be mentioned that because this finding was not strictly speaking necessary to reach its conclusion, the comment about dishonesty was obiter. This video will focus solely on what Lord Hughes' comments were on this obiter issue. His lordship states that it can be seen that there are indeed a number of serious problems about the second leg of the rule adopted in Ghosh. We discussed about this earlier. It has the unintended effect that the more warped the defendant's standards of honesty are, the less likely it is that he will be convicted of dishonest behavior. Secondly, it was based on the premise that it was necessary in order to give proper effect to the principle that dishonesty, and especially criminal responsibility for it, must depend on the actual state of mind of the defendant, whereas the rule is not necessary to preserve this principle. Fourthly, it has led to an unprincipled divergence between the test for dishonesty in criminal proceedings and that in the civil action. Fifthly, it represented a significant departure from the Pre-Theft Act law, where there is no indication that such a change had been intended. And lastly, it was not compelled by authority. In short, the Court of Appeal in Ghosh had misinterpreted the case law before it, and that was part of the reason why we ended up with this unsatisfactory subjective Ghosh test in the first place. Lord Hughes concluded his criticism of the Ghosh test by stating, "There is no reason why the law should excuse those who make a mistake about what contemporary standards of honesty are. On the contrary, It is an important, even crucial function of the criminal law to determine what is criminal and what it's not. Its purpose is to set the standards of behavior which are acceptable. So finally, Lord Hughes decided, and the Supreme Court decided, that these several considerations provide convincing grounds for holding that the second leg of the test propounded in Ghosh does not correctly represent the law. His Lordship therefore proposed a new test. When dishonesty is in question, the fact-finding tribunal must first ascertain, subjectively, the actual state of the individual's knowledge as to the facts. The reasonableness of his belief is a matter of evidence going to whether he held the belief. But it is important to recognize that this is not an additional requirement. The question is whether it was genuinely held. In other words, whilst the question of whether the defendant's belief was reasonable or not is not irrelevant, it is not a separate requirement. It's just a factor to take into account at the evidentiary stage of whether a person held a belief genuinely. Secondly, when once his actual state of mind as to knowledge or belief as to the facts is established, i.e., once the first limb has been established, the question whether his conduct was honest is to be determined by the fact finder by applying the objective standards of ordinary decent people. There is no separate requirement that the defendant must appreciate that what he has done is by those standards dishonest, and this is in complete contradiction with Ghosh. Going back to our Robin Hood example, we can see now that whilst Robin Hood would have been found innocent under the Ghosh test, under the Ivey test, the fact that he believed that what he was doing was honest was not sufficient to keep him out of criminal penalties. Now, despite the Supreme Court's emphatic attack on the Ghosh test, after Ivey, there remained a question as to what exactly is the precedential value of Lord Hughes' comments. Because on the one hand, we have a Supreme Court judgment that was obiter and in the midst of civil proceedings. Contrast this with Ghosh, which is undeniably a Court of Appeal criminal decision. So some argue that in criminal cases, the Ghosh test should still be applied. However, this issue has thankfully been resolved by the case of Crown against Barton Booth in the year of 2020. There, the Court of Appeal confirmed that the undoubted reality is that in Ivey, the Supreme Court altered the established common law approach to precedent in the criminal court by stating that the test for dishonesty they identified, albeit strictly contained in the obiter dicta, should be followed in preference to an otherwise binding authority of the Court of Appeal. In the result, the test for dishonesty in all criminal cases is that established in Ivey.